We are joined today by Sandy Rosenbaum. She's a special education special needs advocate with Littman Crooks LLP. Sandy's the mother of a CCO member and is also part of the Life Plan CCO member and Family Advisory Council. So welcome, Sandy, and please take it away.
Thank you very much, Pam. I am really pleased to be here tonight speaking about a topic that is so important to all of us. And I oftentimes when I speak on educational advocacy, I'm speaking to a general audience. I did try to tailor this to this audience in the sense that everybody here has a loved one with fairly significant needs because you're all receiving care management services and you're all on the waiver. So I've tried to on issues that are going to be specifically important to you. As we said, some of the slides are actually have a lot of text on them, and I might skip over them kind of quickly. You can certainly go back on the recording and pause to your heart's content on those slides if you need to. But I think there's too much information to really dwell on every single slide. So with that, I'm going to take it away and share my screen, and hopefully I will do this properly. Hang on. Here we go. Okay, so cover page. Let me just move. Trying to move myself out of the way a little bit. Okay, that should work. Okay. So again, I've been with Littman Crooks for about 10 years. I'm going to celebrate my 10th anniversary next month. Our core region is New York City and the lower Hudson Valley, but we do serve people as far north as the Capital Region, and we do serve families on Long Island as well. And occasionally we've served people even further north than the Capital Region. And as Pam said, I am the parent of a man with autism who is a member of Life Plan CCO. And he has very significant adaptive needs and also has a few college credits. So he's been a real mix, and following him through the educational system really gave me an opportunity to see a huge swath of it, and I was happy to get involved. So the school system really is your child's most important service provider. As you all know, OPWDD services are only for after school hours. The IEP must provide a program of individualized supports to allow students to make meaningful progress, and that is a mandate. If the services are not provided, you can go after the school system to try to get them to provide it at a later date in an alternate manner. This is something that is obviously very, very, very powerful and is not available in other channels necessarily. Even so, they may not agree that everything that you think is important for your child is something that the school is obligated to provide, and nothing stops you from providing additional services if you have additional resources like health insurance or private pay. The main law that you hear about, particularly if you are looking into resources on a national level, is you're going to hear about the federal law IDEA that provides all children, guarantees all children a free and appropriate public education designed to meet their unique needs and prepare them for future education, employment, and independent living. In New York State, the law that governs it is the New York State Regulations Part 200 that is available on the New York State Education website. It provides all the protections of IDEA and then some. And when you're talking to your school district, they are going to be much, much more familiar with Part 200 and the citations than they are with IDEA. So when you learn something important about IDEA that you want to press, it's really great practice to find where the analogous information is in the state law, because that's what is going to mean something to your district most likely. All students that are covered by an IEP are also covered by Section 504 of the Rehab Act. Although it is a truism that an IEP is a much more powerful and comprehensive document than a 504 plan, there are times when the IEP, Section 504 is actually your best bet to provide the services that your child needs. In particular, because it guarantees equality of access, 504 is often your best bet if you are seeking access for your child to participate in after-school services for which they need reasonable accommodations. The other thing that is also kind of little known is that the Americans with Disabilities Act Title II offers very specific rights regarding communication disabilities and communication preferences. And that's important not only for students with communication disabilities, but also for parents with communication disabilities. So if your child has, whether they're using some type of augmentative communication, or they prefer sign language or whatever it is, they do have a right to be served in their preferred method. And that is something that I encourage you to look into if it applies. Another important law in New York State is DASA, the Dignity for All Students Act. And this is an anti-bullying provision when students are bullied by other students. And so it's just another avenue that you should not overlook if this is a concern for you. Classification for special education. You hear about the 13 categories. If some of you have children who are still in the preschool system, all preschoolers are classified as a preschool child with a disability. And when you get to the school age system, they will be classified under one of these broad categories that the CSE deems to be the category that is most relevant to your child. A diagnosis on its own does not guarantee a particular classification, and it doesn't guarantee a particular service. The services should be driven by the student's individual needs and not by the particular classification that's chosen. There are some exceptions. For instance, the autism classification entitles parents to parent training. And if you are looking for a specialized program out of district, a BOCES, a District 75, a non-public school, those programs typically are approved only to serve students with very specific classifications, and it may be advisable, if you're looking for a particular type of program at that point, to change to another classification that also describes your child. But for the most part, if you're being served in your own district, for the most part, the classification should not provide services or prevent services from being provided. The individualized education program is the document that everybody has. This is the written statement that describes the unique individualized services that are going to be provided to your child. It needs to include the present levels of performance, sometimes called the PLEPs, PLP. Present levels of academic achievement and progress. The IEP includes goals that are designed to help the child make progress in the general education curriculum, ideally, describes how the project progress will be measured. And the other thing that's included in the IEP for children ages 15 and up are measurable post-secondary goals, because the IEP is supposed to be preparing you for life beyond your school career. I saw there was a question in the chat before, what does FAPE stand for? So here we are. I wasn't ignoring you. I knew the slide was coming. Free, appropriate public education. And the definition of free, appropriate public education is the special education and related services that are provided in an IEP designed to meet the unique needs of a child with a disability. And those standards are that the IEP, it is FAPE if the IEP is reasonably calculated for educational benefit. That standard's been in place for quite some time, and a standard that's been in place only for about the last 5 years is that the program must be appropriately ambitious in accordance with the student's needs and circumstances. So those are, if the child's program is not doing that, then you can allege, you have grounds to allege that it is not appropriate for your child. In most cases, a free, appropriate public education should be gearing the child to meet state standards of achievement to the maximum extent possible. And of course, the last one, D, is for free. It's provided at public expense. I'm going to spend a little time on evaluations, and what this slide shows, mirrors, is the structure of the IEP document and the structure of the CSE meeting when the Committee on Special Education is operating by the book, so to speak. The first thing that's considered about the child is evaluations that are available, speaking to the students' speaking to the students' levels of functioning. From the evaluation documents that are considered, the IEP then documents the students' present levels of performance, use the present levels of performance to develop goals that are appropriate for the student to attempt to meet over the course of the school year. And finally, once the goals are developed, only at that point does the committee begin discussing the program, services, and accommodations. And of course, program is sometimes described as placement, because particularly when the program is not being delivered in a general education classroom, it's more apparent that it's a placement. The placement would be the place where the services are delivered. Although they always say it's a program and not a placement, but sometimes very often it is also a placement. So a minimum evaluation that is required by special ed law is going to be just really 2 batteries of tests, an IQ test and some educational achievement testing, as well as a classroom observation, a social history that's typically done by the parent being interviewed by typically a school social worker, and you provide your child's most recent physical exam. If your child does not have one, the school physician can provide that exam. That is the minimum, and many, many times schools will do the bare minimum, but you can certainly request more. If your student is already receiving related services in particular areas like speech or OT or PT, reevaluation, which there isn't actually a slide on this, but the reevaluations under IDEA need to be completed at least every 3 years. So if the evaluations that the district did on your child are more than 3 years old, they are obligated to provide testing for your child, to have them retested to assess their current levels of performance. You do not have to wait for your reevaluation cycle to come around to ask for additional testing. If you feel like the type of service that's being provided is not appropriate or doesn't capture all the needs, you can always ask for a new evaluation. And some of the evaluations that you can ask for, when your child is being reevaluated or really at any time, you might ask for a nonverbal IQ test if your child has significant language disabilities. You do not really want them being tested with some of the standard IQ tests where even the nonverbal sections may be more language loaded than are appropriate for your child. There are tests that are offered by OTs. There are executive function tests. There are reading tests. And sometimes if you think that your child may in fact be, say, intellectually disabled, but they may also have a specific need for specific type of reading instruction. And it's okay to ask for some of these other tests. It's okay to ask for neuropsychological testing because it may be that your child has a specific cognitive function in their brain that is particularly weak, and that instructional style needs to account for that. All of these things are important. The behavioral rating scales, they call them behavioral scales, but they also assess, it's a report of your child's social emotional functioning. Those can be very important. So there's a whole range of things that you can ask for that your district may not be offering up. Once the evaluations are complete, ideally you should be receiving them 5 business days before your CSE meeting, so you have a chance to read through them. A best practice that some districts do manage to do is to provide a pre-CSE meeting where you can have conferences with the evaluators prior to the meeting to understand what the information is. If that's not offered, you can always, you can always decide just to reschedule the meeting on the grounds that you didn't have enough time to look at the information. But separately, the adequacy of the evaluation, if you feel that they find that there's nothing wrong in an area where you fervently believe that that's not the case, you can disagree with the evaluation. You can ask for the district to provide an independent evaluation at their own expense, or you can ask them to administer another type of test that might better show your the areas of need or potentially the areas of strength. There's a lot of ways to disagree. And just one quick thing also about the independent evaluations. If you ask for an independent evaluation, your district may try to put you off in any number of ways, but legally they have 2 options. They can grant it, let you know their approved evaluators, their cost allowances, or they can file for impartial hearing, and they can tell a hearing officer why their evaluations are so comprehensive that they're not going to pay for you to have the independent evaluation that you're entitled to. So keep pressing if they say no, and let them know that you know that they're obligated to do it or file for hearing. The goals on the IEP so often are not as specific or useful as they should be. SMART goals is an acronym that shows up outside of the IEP realm as well. But it is just important to think about that the goals be specific, measurable, achievable over the course of the school year, relevant, and timely. And timely both means that this is an appropriate time in the child's life to be working on those skills. And it also goes to achievable, that it's a goal that is appropriate to reach for that level of progress for the current year. Districts like to set goals sometimes very low because then the child has a better chance of meeting those goals, but it may not be appropriately ambitious, to go back to the term that I used a little earlier. Something else to be aware of, the middle box here, for both preschoolers and for students who qualify for the alternate assessment, and there'll be more about the alternate assessment a little later. Short-term objectives and benchmarks are also developed for the goal. So if a school has a report card, say 3 times a year, you should have 3 benchmarks for that, or 2 interim benchmarks for that goal, so that there should be a specific goal for each marking period to keep everyone on track in terms of working toward the annual goal. Another important principle of special education law is the principle of least restrictive environment. The student is supposed to be served to the maximum extent possible in the same classroom that they would be served if they did not have a disability. Sometimes that's not appropriate. They should, and then you can place them in a special class. But even when you place them in a special class, that's only when their needs cannot be met with supplementary supports in a general education classroom. And it's not necessarily for the whole day. It could be just for academic classes. It could be that the student is guaranteed at least to be with general education students for PE. And the other thing is that students need to be served as close as possible to their local school. So that, I guess, can sometimes work against you if the school across town might have a better reputation, or you might feel more comfortable with it. You would need to be able to explain why, to be able to make the case for why that environment is uniquely suited, because absent understanding the uniqueness of that environment, the district is going to default to the one that is least restrictive, that is closest to your home. And the tension between the access to non-disabled peers and specialized instruction is tremendous. A lot of parents do want their children to be receiving services from very, very well-trained teachers and therapists, or teachers and therapists with specialized training. Sometimes that specialized training is not available in a local district or in a community school in New York City. And then you really need to decide what is most important. So just putting that out there, that's a tension that could be used against you, and you just need to be aware of it to understand how to advocate. The continuum of services is really pretty wide, and because of the nature of this crowd, I did pay particular attention to the more restrictive and more supportive end of the continuum. You know, the least restrictive is that a student is just receiving related services and maybe some supplementary aids and services in a general education classroom. They might be receiving services from a consultant teacher who may not spend any direct time with them, but may spend as little as 2 hours a week working with their general education teacher to modify the curriculum or modify worksheets or assignments in a way that's appropriate for them. The resource room is a 5-to-1 period. This is called SETS in New York City. And it's class time to work towards the IEP goals. And it's a 5-to-1 setting, so it's quite small, but it may be pretty diverse in terms of the ages of the students or what classes they are working on or what their skill needs are. Integrated co-taught, it looks like a general education class, and indeed most of the students in there are general education students. And then a small proportion of the students are there because of the nature of their needs, which are more significant than for resource room or consultant teacher. And those students have the benefit of a full-time special ed teacher. Sometimes integrated co-taught, again, is offered for a partial day. In some elementary schools, it might be offered only for the math block and the literacy block. And so that teacher is only there for part of the day. Special class, again, in New York City, that can be either in a community school or in a specialized school. But we're talking here first about community school, and the special classes can be all different sizes. In general, the smaller the class, the more intensive the setting and the more individual support. The exception to that is that the 12-to-1 to 4 is a highly supportive setting. That those 4 paraprofessionals are there in addition to the 1 teacher, before you account for any additional staff that that any student may be additionally entitled to. After these classes in a community school or in the home school district, the CSC may be looking for classes either in another public school district, in BOCES, which has its analog in the DOE in New York City with District 75. These are public school classes that are offered on a regional basis and tend to be more specialized than those that are available in the community schools. After the BOCES in District 75, the next level is the state-approved non-public schools, first day, and then residential. And the most restrictive setting is home and hospital instruction that's provided 1-to-1 for individual students, either in their homes or, as it states, in the hospital. The amounts of time on that have recently gone up, and it's now 2 hours a day for elementary and 3 hours a day for secondary school. And that's a meaningful increase from what it was before, 1 and 2. Just quickly on extended school year, some of your students may qualify for extended school year, and it's important to realize that ESY services are provided specifically to prevent substantial regression, and therefore those programs typically offer fewer sessions of related service than the year-round programs, because the goal is maintenance and not progress. And depending on the class size that your child is placed in, they may be entitled specifically to extended year service based entirely on the makeup of the class and the needs that that program serves. For other students, a specific statement demonstrating that they're at risk of regression over the summer needs to be documented. Each age, really, there are certain themes that I've found emerge over the different ages of a student's development. When the student's very young, a lot of parents are surprised to see that between preschool and kindergarten, it's a switch from developmental focus to educational necessity. Physical therapy is the first service to go, and It's less about whether your child can keep up with their peers on the playground and a lot more about whether they're able to safely navigate the educational building that they're in. In grade 3, and this is going to come up again through the years, that's the first time that there's state tests that are high stakes. And for many students, this is the first time that New York State alternate assessment is broached. We'll talk more about the alternate assessment later. A lot of parents do worry that the next generation standards, what used to be called the Common Core, might not be the ideal presentation of information for their child. At the same time, there is a lot that can be done in the classroom, particularly really all the way up through middle school, to be able to allow students to participate in grade level curriculum in a way that is meaningful for them. And there can be significant advantages to deferring the discussion of alternate assessment to a later time. Elementary to secondary, really just departmentalization, that a student that may have a particular weakness in math but be stronger in language arts will have the opportunity to be placed in different settings for different subjects. When you get to high school, you do kind of hit more of a brick wall with respect to the alternate assessment. If the student is really unable to keep up with the courses as they are taught, to the high school credit standards, and very often to the requirements for Regents exams, if it is hard for them to learn meaningfully under those circumstances, then it may be appropriate to explore alternate assessment. Alternate assessment means not only that you're not going to earn a diploma, but that you're not even going to be attempting diploma level work. So it is a very serious decision, although it certainly is very appropriate for a lot of students. And just one thing about the high school level, there's been a lot of discussion over the past few years about laws that allow districts to educate students through age 22. Unfortunately for us, those laws permit but do not require districts to do that. So very, very important to be aware of. Again, about the alternate assessment, if you look at the top of this slide, and I'm not going to spend the time on it, but when you go back and replay it, you can pause. The requirements are really pretty stiff in New York State for a student to be placed on the alternate assessment. That second bullet is huge. Many students who struggle to succeed do not meet those very strict criteria for alternate assessment. And so if your child is betwixt and between, you need to recognize alternate assessment is for students with very, very intensive needs, and they are ineligible to earn a high school diploma. Alternate assessment coursework does not provide high school credits, so you're not even earning the credits towards a diploma. So once you make that decision in high school, although theoretically you can turn back and change your mind, certainly once you're at the high school level, it's not really going to be possible. I have a number of slides on transition. I'm going to try to go through them relatively quickly. It is a required element of the IEP at the high school level, and it goes on until the age out at age 21. When the IEP begins to focus on transition, you may feel that the IEP is focused less on academics, and you may be concerned about that. There really are things that are not academic that your child must learn before they finish school that are really important to prioritize. And you need to understand and you need to discuss with the school, and hopefully you can reach consensus on which things are most important. For those of you whose children are not on the alternate assessment and do have a real chance to graduate from high school and earn a diploma, you need to understand that your eligibility for special education ends as soon as you earn that diploma. This is particularly important if you're placed in a non-public school that will grant a diploma without Regents exams. Because Regents exams so often are the sticking point for so many of our students. So you may find yourself graduated precipitously when you thought you had a lot of time for transition planning. Because you don't want to be forced out earlier than you need to start talking to the CSE as early as 8th or 9th grade about how to structure and maybe stagger those course requirements for graduation so that your student does have time to work on their transition skills and the life skills that they need for transition, in addition to meeting their academic requirements, because that's a true nightmare when the student meets all their academic requirements at age 18 and then they're out. If you do for some reason decide to leave school and your child is not yet 21, you decide to try adult services and it doesn't work, you can go back to school until age 21, even if you exit it. You're entitled to come back and access your free appropriate public education. In terms of your life plan, there are things that your care manager can do. You can invite your care manager to your CSE meetings to participate in the meetings and hear what the school is offering or not offering. I think it can be very helpful in terms of understanding, each person understanding what they are focused on and whether there are areas that nobody is focused on, and you can try and make sure that someone steps up. Some districts have transition coordinators, many do not. In Westchester County, where I live, we're fortunate that the county Department of Community Mental Health does have a transition coordinator that does monitor all the students that are transitioning. So there are various people that can be involved. When you're starting to think about it, you need to research day programs, determine requirements. If your student has always had a one-to-one, they are not going to have a one-to-one if they go to a center-based day program. So you need to find out what needs to happen in order for your child to be eligible for the types of programs that are available, and to ensure to the maximum extent possible that you have prepared for that day when they're no longer in school. If you're not on self-direction and you're planning to do self-direction, it can take a long time to launch. So start that way before you're ready to graduate. Existing plans are going to need to be set up to authorize day programming, whether these are self-direction plans or traditional plans. So make sure you understand how that works, that you have the opportunity to view day programs or view whatever programs you want to look at. And if you have never worked with ComHab, you want to get started right away to try to find staff that is going to be appropriate to work with your child, and hopefully that would be available during the day when they're going to have a big hole. There's so many different ways that students can go to school. There are college degree programs for those who are appropriate. There are many, many non-college degree programs that take place on the college campus. thinkcollege.net is a great place to see how what programs are available and how your student can reap the benefits of inclusion that they may have reaped in high school, even though they are not academically prepared to succeed in college class and earn credits. For some students, people like to look at independent living programs. These hopefully will prepare your child for a less restrictive housing option than might otherwise be available to them later on. Some of these programs you may be able to fund to a limited degree with self-direction. Many you cannot. Access VR may help with testing, may help with job training, may help with looking for a job if Access VR judges your child ready to benefit from their services. And then, of course, your care manager should be talking to you about all of the continuum of adult services that's available through OPWDD. If your child goes to college, just a quick note that what you're going to have in college is not really an IEP. It's much more like a 504 plan. Colleges make their own decisions. Just a little bit about how families sometimes end up in impartial hearing. Very often, it's because the relationship is not cooperative, and you do typically want the relationship to be as cooperative as possible for a variety of reasons. And there's a lot of different reasons. Parents and districts look at children with different lenses. They may understand things differently. They may have different preconceived ideas, but it's very easy to come to an impasse with your district. To try to be more cooperative, the first thing is to try to realize that most of the people who go into this career on the CSE side, in theory, everybody is trying to educate the child appropriately. And hopefully you can see that they may be doing the best they can. Try to look at them in the most positive light. And the main reason to do that is if you do need to go to hearing, you will need to establish at that point that you have been as cooperative with the district as you can. Good communication is really important, and you understanding where the district's obligations end and the district understanding what their obligations are as well. Everyone needs to understand their obligations. If you disagree with the CSE, the number of times I've seen on a Facebook board or something that people say, I can't believe it, I disagreed, and they wrote the IEP that way anyway. That is their right. They can write an IEP over your disagreement. You need to express that disagreement at the meeting. If you think there may be a disagreement, by the way, you can request to record the meeting. You notify the district the day before, 24 hours in advance, that you want to record the meeting, and you have the audio tape running while the meeting is going on. You express your disagreement on audio. You follow up with a letter. You can follow up again when you get the IEP in person. Hopefully they will come to the table and discuss it with you. If they don't, then you consider remedies. So again, disagree in writing. Whatever happens in writing, you have a conversation with them, you're appalled. Maybe it's not time to write an email, but write it down for yourself in a note to self or some kind of log. Because if you don't write it down, it didn't happen. When you are writing to the district, these are some steps that are important, and the last one is very important. If you are really angry, pause. Don't write it until you don't send an email until you calm down. Everything that you send to the district could be an exhibit in a hearing, and you really need to think about it as though it was going to show up on the front page of the New York Times. So the ultimate thing that you can do, a lot of times you're at a meeting, if you say you disagree, sometimes the CSE chair will just say, well, you have due process rights. So some of the reasons why people file for due process when they have an impassable, they've really come to an impasse with the district. It might be over what type of placement the child's in. Maybe the district wants your child in a placement that's too restrictive. Maybe it's not supportive enough. Maybe they've refused an evaluation. Maybe the related services are not appropriate or not the right amount of related services. Maybe you've identified a private school that is going to provide an appropriate education when your home district can't, and you want to seek tuition reimbursement. Other tools you can use, you can go to mediation instead of going to hearing, which can feel more collaborative. I know that our firm, in general, we as attorneys can use the impartial hearing process in both collaborative and more confrontational fashion. And many law firms are less likely to use the mediation process, but certainly open to you. You can also file complaints. The thing about filing a complaint is that's usually not the best avenue to get the services that your child needs. What it is appropriate for is if something has happened to you and you want to make sure it doesn't happen to any child ever again, then a complaint is more likely to be the appropriate forum. And the remedies that you can seek when you file for due process could be tuition reimbursement, could be makeup services. I would say that those two are the most common. One other thing, I guess, about transition and about things you need to think about at the end of school. It's not really an educational issue, but it is something that your school should bring up to you. And if they don't, you need to look for it on your own. One of them is that your child is going to be totally free to make their own decisions at age 18, or they are going to be presumed that they can make their own decisions no matter how disabled they are. So you really need to consider guardianship or another way that you can assist them with decision making, whether that's supported decision making and or a power of attorney. And the other thing that schools should be doing towards the end of your high school career is speaking to you both about public benefits and about connecting you with Access VR if that's appropriate. I'm not sure if it's still true. They have said in the past, as early as 2 years before graduation, certainly the year before, a lot of Access VR often has programs that assist students in getting a summer job the summer before senior year. I've reached the end, nothing, and I'm sorry it took so long. I had hoped to have more time for Q&A. I don't know how long people can stay on. But this is not legal advice. This is educational. Please consult with your own attorney, and you cannot reproduce this, please, without the express permission of Littman Crooks LLP. Leave my contact information up